Hey, welcome back to another video blog. I'm Patrick Carodi of Carodi Law. With me again is Matthew Thomas of Matthew Thomas Law. Matt, how you doing this afternoon?
Hey Patrick, how are you?
Oh, I'm good, buddy. Thanks for asking. And so again, if you're watching this, you probably have a military law issue. And as a reminder, keep your mouth shut, make no statements, and don't consent to any type of search, whether it's your DNA, your cell phone, your barracks room, your car. Don't consent to anything. Now, we're going to talk this afternoon about a charge sheet, a DD form 458, and a charge sheet is a document that formalizes charges against a service member. And a charge sheet is needed if the service member is going to go to an Article 32 preliminary investigation, to a summary court-martial, or to a special court-martial, and also ultimately a general court-martial. And so let's get started, Matt, and I'm going to go ahead and put a DD form 458 up here, and why don't we get started talking about it?
So Patrick, one of the first things I wanted to ask you is when a client brings you a charge sheet, what is one of the first things that you look to?
Well, really, the first thing that I always scan to is what the charges are and specifications are, and that's really the meat of the charge sheet. And on the first page, in the middle, or it can also be on additional pages if the charges all don't fit in block 10. And then I also often flip it over, and we'll talk about this a little later, to the referral block, which is block 5 on the second page, because that tells me, what form it's going to, whether it's a summary court-martial, a special court-martial, or an Article 32 preliminary investigation, or if it's already been forwarded and referred for trial by general court-martial. So that's really where my eyes go to first. But the top, block 1, personal data, and I will tell you, Matt, I don't know. It's been a long time since I saw a charge sheet that didn't have errors in personal data. Is that also common in your experience?
I mean, Patrick, one of the first things that the judge asks once we get into the courtroom is he usually asks not only the trial counsel, but the defense attorney, hey, have you guys checked over the data on the personal data section to make sure that it's all correct? And that is something that we see over and over again, where either the clerks or whoever's had their hands on this really just makes errors, and they just jack up some of the information that's in there. And that becomes important later on down the road when the judge is making his own calculations, and even when it comes to forfeitures and things like that. And it's a very common mistake that we see.
Now, as your client, the accused, is not going to get a windfall if there's an error in the personal data. I've had clients come to me and say, they got the wrong guy, they got me at the wrong pay grade. There's no relief because they can easily do what's called a pen and ink change, right? You're familiar with that, Matt, aren't you?
Yes, it's called a minor change.
Yeah, they literally can just take a black pen and line out the error in the personal data, and correct it. Now, the only thing I'll point out in section 1, the personal data, is block 8 and 9 can be important also if there's any type of pretrial restriction or break time imposed, pretrial restraint. And that can be an issue you want to bring up with your attorney if you have been given some type of restriction or some type of restraint or conditions on your liberty, or even if you think you've been treated differently than other members. That's something you'd want to bring up with your defense attorney.
And before you move on, box 4 and 7, the pay grade and the pay per month, why does that become an issue, especially right around the new year in January?
Right, and it's obviously because the pay raise that Congress so generously gives the service members takes effect, and so you do see a lot of changes in the pay. And as you said earlier, Matt, it ultimately becomes important if you're talking about fines and forfeitures and things of that nature. the financial penalties that can result of a court martial.
Now, Patrick, the next thing I wanted to kind of talk to you about was block 2 and the charges and specifications. Now, one of the first things that people ask me when they come into my office is, hey, Matt or Mr. Thomas, what's the difference between a charge and a specification?
Yeah. So a charge is simply the number of the UCMJ article that's violated, whether it's 92 or 112 alpha or 120. It's just the charge. So it's the section of the UCMJ that's violated. And under, each UCMJ article, there could be multiple offenses. And what the specification does is the specification spells out with specificity the actual violation, the crime that's being alleged. And so you can have multiple specifications under a charge. Now, if you have one charge, so let's say it's violation of Article 112 alpha, which is the military's drug crime statute, you could have 1, 2, 3, 4, 5, 10, 20 specifications under there, each alleging a discrete criminal act. And the thing about a specification is the maximum punishment is based on the specifications and adding them all up. So it's not just if you have one charge but multiple specifications, it's not just one maximum punishment based on the single charge. It's based on the cumulative adding of all of the specifications alleged under that charge. Does that get to the point you're raising, Matt?
Yeah, Patrick, just to kind of spin it back to you, just to make sure I know and that our viewers know, is the charge just the overall violation, and then the specification that's under it is the amount of times that the accused has violated it, or the different ways that the accused has violated it? Is that a pretty good sum of what happens?
Yeah, and I'll give you a great example, right? You could have charge violation of Article 112 alpha, right, the drug crime statute, and then you could have specification 1. Did on or about this date wrongfully use cocaine, right? And then you could have specification 2, did on or about a different date possess cocaine, right? And then you could have specification 3, did on or about, this date distribute cocaine, and that would all fall under one charge of Article 112 alpha, but 3 specifications.
Well, why is it important for guys like you and me, people who've had experience writing these charges and looking at these charge sheets, to really go over how that specification is written?
Well, and that's a great point, Matt, because there are requirements for each specification. There are certain things that the specification must establish. They must establish jurisdiction. They must actually establish that a crime was committed. That is, they need to allege all the essential elements of the offense, right? So that's important. And they need to include words of criminality. If they don't include words of criminality, it's not an offense. So there's this thing called a failure to state an offense. And if they actually fail to state an offense, it's a very technical review, as you know. But if the if the charge fails to state an offense, there may be a motion there to dismiss.
Yeah, and that's something that we see with a lot of inexperienced prosecutors who are just kind of cutting their teeth, getting their feet wet, and when they send over the charge sheet for the first time, sometimes they don't catch those mistakes that we see reoccurring, no matter whether it's the person's first time writing that charge sheet or if it's their 1,000th time. It's a very technical and nuanced thing to write the specification for an actual criminal charge, and it takes an experienced set of eyes to go over that to make sure that they are hitting all the wickets that they need to in order to make sure that they can survive a court martial. Now,
yeah, I mean, the easiest one is like larceny, right? What is it, over $500? It's an enhanced sentence, right? So if the specification doesn't allege an amount, even though we all know the value of what was stolen was more than $500, then you go into court and the maximum sentence is going to be the lower number and not the higher number. And if you get past arraignment, that is locked in, you know, in a lot of ways, and they can't go back and amend it to be a greater offense.
Now, when we go down to block 3, the peripheral block, you know, who can, I see here that it says signature of an accuser. You know, who can that accuser be and who can it not be?
So, all right, let me tell you sort of the war story, Matt, that I used to tell new judge advocates when I trained them. Okay. This is an antiquated system. It came about back in the day where, you know, one soldier would go and say, hey, you know, this other soldier, you know, beat me up. He assaulted me and battered me, and I want to press charges. And so they would, you know, write up the charge sheet, and that victim essentially was the person accusing would go and, you know, and swear to those charges and say, hey, I have personal knowledge of this. This is what happened to me. And they'd swear out these charges. And so that's really the origin of it. And it's not much different than the origin of really criminal law in the United States. I mean, you used to have people that would go in and say, hey, I'm a victim of a crime. This happened to me. I'm going to swear that this happened. And that would give the grounds to, you know, go forward, what we'll talk about on the back page. What it's really been reduced to, Matt, as you know, is someone who works in the prosecutor's office, reads the, you know, investigation and, you know, says, well, I've now investigated it. And, you know, I'm going to assert that, you know, the charges, which, you know, the UCMJ has become very complicated, right, and very technical, that these charges are true to the best of my knowledge based on my review of these documents that the prosecutor gave me and told me to review. It's almost a sham.
Now, Patrick, stop right there. You said that the accuser had to review. Why is it important that they review those documents?
Right. And this is a motion that you can raise, is that because they're swearing to it that they, you know, that the charges are true to the best of their knowledge and belief. And so if they don't have all of the information, whether it's because they personally investigated by interviewing witnesses or because they read documents that supports each and every charge and specification on the charge sheet, essentially they're violating that oath that they're taking.
Right. And when we've seen case law recently that was let out by the appellate courts that said, you know, when the charges and specifications don't match the evidence that it has been presented, you know, that's a motion to dismiss. That's a motion right there, right off the bat, that, you know, a good attorney who's gone through this thing with a fine-tooth comb and really looked at everything from both a big picture and a small picture, they can make that evaluation on whether that is a motion that they can file for your case.
And Matt, I'll tell you, it's extremely bothersome to me that, you know, that we have people that swear to these things that don't even care. You know, they don't understand that this is a legal document. It's very significant to our clients. They are swearing out charges. They are putting our clients' career, their livelihood, their liberty, their life, all in jeopardy. And to them, it's like, oh yeah, before I go to lunch, I'm just going to, you know, sign this charge sheet. And, you know, it's really more than that. It's an oath. It's a significant oath. And it's our job as defense attorneys, if they're not taking that oath seriously, to, you know, to ensure that we challenge that.
And Patrick, I just flipped over to the charge sheet that I have in front of me. And when you go over to block 12, and it says that the accused has to be informed against the charges that are being presented against him. Are there implications to the timing of when the accused was informed?
Generally, they're not. They're supposed to be informed as soon as practicable. The one thing I would tell you is that when preferral begins, there's a speedy trial clock that starts. It's 120 days where they have to get the accused before a military judge. Now that 120 days is not hard and fast. There's some ways for the government to get some more time. There are ways for the defense to request more time. It's called excludable delay. We're not going to go down that road, but that's why preferral is important. But, you know, I would tell you from my experience, and when I was in charge of a prosecution office and when I was a staff judge advocate, I would always make sure that, you know, we moved as fast as possible to inform the accused that there have been, charges levied against them. And, the way they do this, I mean, there are really two ways to do this. The easiest way to do it is you bring the accused in and you just give them a copy of it, and you tell them to go see the defense office. Sometimes you have people come in that want to, read the charges to them. That's not required. It's really just informing them of it. But really the easier way to do it is just to give them a copy of the charge sheet. Now, for our viewers who think they're going to get a charge sheet, so they're watching this, if you get called in and you're given a charge sheet, Matt, what should you do?
You call your attorney. You call one of us.
And keep your mouth shut, right?
That's right. That's right.
Don't say anything. It's not the time to defend yourself. There is no defense to be had at that point. You literally take the charge sheet, or even if they give you a copy of it and don't let you take it, you should say, hey, can I get a copy of that? And they should give you a copy, but it's, keep your mouth shut. And this is a bad thing that you get a charge sheet. Matt, let's go to block 4, receipt by summary court-martial convening officer. What's the purpose of that?
Well, there are certain people that have to sign a charge sheet before it gets itself into court, and it's got to go through multiple levels of review before that it can even be brought in front of a judge. And here you see that the commanding officer has to sign this because he's the person that's actually going to be convening this court-martial. So either, the SJA or the prosecutor or the adjutant, even at times, has to make sure that they are taking this to the commanding officer and making sure that they are informed and that they are actually signing this before it moves forward.
And I'm going to take you back in history again, okay? So go back to history, right? Remember I was talking about, like, the soldier gets beat up, he wants to press charges, comes in, he swears to it. Well, the commanding officer of the guy that allegedly beat him up has to now know that this is an issue, right? And so that's why this block exists, is that this block is like, hey, there's now an issue. And then back in the day, the theory was, right, the commander now knows that there's a charge, and like this would be the first time the commanding officer found out that there was a charge. But like in today's environment, Matt, is like when the commanding officer is given a copy of the charge sheet, is that going to be the first time he knows something's up?
No. Usually he's been getting briefed from the moment that these allegations have been made, whether it be in that weekly meeting or just in passing when he's sitting down with his SJA and having some of those discussions with prosecutors about other cases. He's typically tracking on what's going on with each of the cases. And by the time that this charge sheet comes across his desk, he has an idea of where it's going to go after this. Now,
I would tell you, I think he knows exactly what he's going to do with it, and it's just a speed bump on the way to court-martial, right? Because they don't go through all the effort to prefer charges these days unless they actually intend to send it to an Article 32 or a court-martial. I mean, that's my experience.
And Patrick, you were hitting on something at the beginning of our discussion on that box 5, the referral and services charges sheet, and you said one of the first things that you look to is what kind of court-martial is it going to? Now, how does that affect your analysis on what you're going to talk to your client about?
Well, right. If it's not completed when my client comes to me, there's a couple options, right? Number one, it's that they've already decided it's going to an Article 32 preliminary investigation, which is a speed bump to a general court-martial, right? Or maybe they're on the cusp of sending it to a 32 or a special court-martial, and maybe they want to give the guy or girl time to talk to counsel to see if maybe there's a plea agreement to be had to keep it at a special court-martial. But it's important because if you're at a special court-martial, and there are now 2 types of special court-martials, right? There's the military judge alone and a traditional special court-martial. But a military judge alone special court-martial caps punishment, no bad conduct discharge, and confinement maxed at 6 months. A regular special caps confinement at 12 months if you're enlisted, and a bad conduct discharge, no dishonorable discharge. And so I look at that because that sort of tells me what the stakes are. What are the stakes here, and in which direction we're heading. It also tells me, before I can look at the evidence, really, like, how serious does the command see the misconduct? Is that similar to your impressions of looking at that block?
Yes, that's one of the first blocks that I look at as well. And that really tells me, hey, what is the temperature, or what is the tone that the command is trying to set here with the charge sheet. And sometimes, we see that is a leveraging tool for the command when they set that tone, and it's their shot across the bow to the accused and saying, hey, we're taking this serious. You need to straighten up and fly right, as an old mentor that used to tell me. And that changes our posture as well, and how we advise, and how we kind of dictate what's the next steps for that client.
And so let me just point out quickly, if you have a charge sheet and you're wondering where to look on this, it really is this referred for trial to the blank court martial. That will either say special, or it could say general if you've already been to an Article 32 or you waived it. But that block right there is really the important one. And again, this is also one of those blocks, as a lawyer, that the untrained person really doesn't know where to look. But sometimes you see errors in this block, and that's important, because this is a jurisdictional procedural issue that has to be correct. And and you have to make sure that the officer who signs it has the authority to sign it, that there's a convening order, which is a magic name for a piece of paper. But you have to make sure all those things are there. And if they're not there, again, that could be a motion that could lead to some relief. Matt, let's jump down to the bottom. Block 15. Why don't you tell them what block 15 is?
So you see, again, it's another iteration of the charge sheet being served on the accused. Now, this is important because the accused has to be served this before being taken to an arraignment. Now, there's a different amount of time for, depending on which court martial that they're headed to, but unless that time it is served on them in the amount of time frame that is designated by the UCMJ, then the accused could have an objection to say, hey, I shouldn't be here. I haven't had enough time to review this with my counsel. And that's why the rule is the way it is because, the whole process doesn't want this charge sheet to be sprung on the accused. And they want to make sure that there's enough time for the accused to be able to review it themselves, review it with their counsel, and then talk about it and see, hey, what do we need to do in order to be prepared once we get to that arraignment?
So you bring up a good point, Matt, and we'll probably end on this, is that, so I get a charge sheet and it is completely filled out, like both sides, all the way through block 15. I got it. What can I expect next?
So what you can expect next is that you will probably be headed to some type of arraignment in the near future.
And what does arraignment mean? I mean, what does that mean?
All that means is that's going to be your first appearance in front of in an actual courtroom. You want to get your chucks or your bravos ready, or if you're a Marine, or you want to get some of your formal attire if you're in any other service branch. But what you need to do is you need to start talking to your attorney, and you need to start making sure that you are prepared for what is to come ahead. And that typically is where they're going to establish the TMO, the trial management order. They're going to give you another reading, or the option to have another reading of the charge sheet in open court in front of everybody if you want to. You can file motions if you want to. You can also elect what forum that you're going to go to. And all what a forum is just, hey, are you going to go to a jury? Are you going to go to a judge alone, or this and that? And all of those things are topics of discussion that you need to have with your attorney before you go to the arraignment, because those are things that are going to set the tone moving forward for what's going to happen in your court martial.
Yeah, and that's right. I mean, it's really turning the case over to the judge, right? And now you got the judge, and the judge is going to be the one calling the shots and And, the judge has, believe it or not, the judge has control over the prosecutors, has control over the defense, right? And even really the commanders at the end of the day, because now the judge owns the process. But you're right, Matt. I mean, the big thing, after you have that completed charge sheet, is the next step is, hey, buddy, you're going to court. Like the time for this to like go away is past. It's not going to magically disappear without some great legal work or something else. So last question from you, Matt, before we go is when before the charge sheet, once you have the charge sheet, what point should they be reaching out to people like you and me?
As soon as possible. As
That's
soon
right.
as they start believing that they might be accused of something, they need to contact you or I, because what you just said a few moments ago about you're now in court. The time to make this go away is over. Right. And one of the best things that guys like you and I can do is we can shape the battle space and shape the narrative. Well, not only with the command, but with the investigation and what some of the evidence that they have in their hands, and hopefully we can avoid a court martial if possible. And if we can't avoid a court martial, what we've been able to do at that point is shape how that court martial is going to look once it actually occurs, and it's going to shape it to our client's benefit. So
yeah, I think that's true, and I also think that there is like a well-being component to it all, right? Because military attorneys, they're not going to form that attorney-client relationship with you until you actually have charges, right? I mean, that's been my experience across all the services.
Right, they're too busy right now where they can't be there right when the accusation is first made. They have a docket themselves and a caseload themselves that is just monumentous. I remember being on active duty and sometimes wondering if it was ever going to end, if I was ever going to be able to climb out of the caseload I have. And that was even when I was getting cases that, already had charge sheets. And so not only are they not able to get on the case that early, but they're also not going to be familiar with the facts as much as they would probably like to be at that point.
Yeah, and I know, Matt, I know you've done it. I know I've done it. I've gone to, OSI, NCIS, CID. I've gone to all these interrogations with my clients. If I'm not local with them or I can't get there in person, I get on the phone and I listen to make sure they don't push my clients around, right? And I know you've gotten this. I mean, we've also gotten because of our relationships with the military prosecutors, we've gotten evidence before, the charges actually came, and so our clients can look at it. I mean, and we can look at it and like you said, shape the battle space beforehand.
And what you hit on right there is I can't tell you how many lives are different today because somebody called an attorney before they walked into an interview or what it really is, an interrogation. And we're able to talk to somebody like you or myself and say, hey, what do I need to be doing? And that's why those discussions as early as possible are so important, because those change the trajectory of a case and they change lives.
All right. Well, again, Patrick Carodi Law, free consultation for military law matters, 904-383-7261. I'm in Jacksonville, Florida. Matt Thomas, go ahead.
And Matthew Thomas Law, PLLC. I've got Jacksonville, North Carolina covered, and you can call me at 910-939-0263.
All right. Thanks a lot, Matt. Appreciate you getting on.
Thank you, Patrick.